Hey class, welcome to week 9. So you might recall that agency action technically breaks down into rulemaking and adjudications. So we've covered rulemaking, now it's time for us to take a look at agency adjudications. As we talk about the procedure for agency adjudications, keep in mind that these processes exist in part because of the due process clauses in the 5th and 14th Amendments. We are entitled to due process of law before being affected by government action, and a formal adjudication, in this case, would be the process that is due. But knowing it's the process due isn't quite enough for a proper definition of adjudication. According to the Administrative Procedure Act, an adjudication is an agency process for the formulation of an order. Typically, that process investigates the facts of the case, determines the proper way to interpret an existing law, and then applies that legal interpretation to the facts of the case. If this sounds similar to a court trial, that's because it is. Formal administrative adjudications are basically the agency equivalent of a trial, and formal adjudications always include a trial-type hearing. Now, sometimes it can be challenging to determine an adjudication from a rulemaking. For example, there are two different matters, there are both cases, involving taxes levied on Denver residents, one of which is a rulemaking and one an adjudication. So rulemaking creates regulations that apply to a class of similarly situated people, whereas an adjudication only applies to the parties in that particular matter. So rulemaking is concerned with broad policy, adjudications are concerned with the facts of a specific case and how to apply the law to those facts. So, for example, if the city of Denver levies a tax on all residents, that's a policy, it's a rulemaking. But a tax that is levied only on a few residents of a specific street in Denver is an adjudication. The APA specifies procedures for both formal and informal rulemaking, but for adjudications, it only specifies the formal procedures. The APA really doesn't address informal adjudications, even though the majority of agency action turns out to be informal adjudications. So some examples of informal agency adjudications would be approvals or rejections of permits or other licenses, approvals or rejections of grant applications, and things like orders to remedy code violations. The APA only requires that agencies give prompt notice of the outcome and a brief statement of grounds for the agency's decision in any type of informal adjudication. So for example, if a government contractor bids on a contract but does not win it, the agency has to promptly notify the contractor that it didn't win, and it has to give a really brief statement about why it didn't win. Similarly, if you didn't obtain a permit before you started re-roofing your house, local code enforcement will give you prompt notice by slapping a stop work order on your door, and that stop work order is going to contain the brief statement of grounds for the agency's decision, and most likely that is going to be some reference to a local ordinance that you violated by not obtaining the permit. Now, I've mixed federal, state, and local here. Obviously, the APA itself only applies to the federal government, but like I said earlier in this semester, pretty much every state has its own version of the APA, and it's nearly identical to the federal version. Now, the fact that the APA doesn't really address informal adjudications does not mean that agencies can just do whatever they want. So first, if an agency has adopted its own rules and procedures about informal adjudications, it has to follow them. Second, both the President and Congress can impose procedural requirements on agencies. So in other words, they can give the agencies instructions on how to hold informal adjudications. And third, the results of an agency action, including an informal adjudication, can be appealed to the courts. So here's an example of an agency adopting its own procedures for informal adjudications. Back in week 2, I mentioned that because of a division of authority, the USDA regulates all meat-based foods we eat, like pepperoni pizzas, but the FDA regulates non-meat foods like cheese pizzas. So if you own a plain cheese pizza manufacturing plant, and the FDA wants to withdraw your qualified facility exemption, it's got to follow the rules that it created to govern that informal adjudication. The FDA will sometimes hold hearings as part of its informal adjudications, as do other agencies. But in many informal adjudications, there is no hearing. Everything is basically handled via paperwork. Because formal adjudications are the agency equivalent of a court trial, the Administrative Procedure Act says quite a lot about them, and that's what we're going to focus on in today's lecture. So in the APA, Section 556 sets forth requirements and procedures for hearings in formal adjudications, and Section 557 sets forth requirements for agency decisions. Think back to our rulemaking lecture and recall that agencies only use formal rulemaking procedures if the statute contains those magic words on the record and after an opportunity for hearing. Those same magic words apply to adjudications. If a statute states that an agency's action must be on the record and after an opportunity for hearing, then the agency's got to use formal adjudication procedures when enforcing the statute. So those magic words require an agency to conduct a full trial-type hearing with a written decision that includes the agency's findings of fact and conclusions of law. So what that means is that agencies have to issue something similar to a court opinion. Addresses the facts of the case, the issue of law, and then applies the law and explains its rationale for doing so. So here are some examples of formal adjudications. The most common example is when an agency determines that a person or an organization has violated a regulation, or an agency alleges they have violated a regulation, in which case the agency can require an adjudication. So basically, the agency takes that person or organization to court within the agency to determine if they violated that regulation. But that court, again, is not an Article III court. It is located within the agency. So for instance, the Consumer Financial Protection Bureau, it can initiate an administrative enforcement action against a payday lender alleging a violation of consumer protection law, and then that would move on to a formal adjudication. Another example would be an agency's decision to issue, suspend, or revoke some type of license or permit. And that can include a driver's license, a license to practice medicine or law, a permit to discharge waste, etc. If an agency suspends or fires an employee, that employee has a right to object, in which case the matter turns into a formal adjudication. That's another example. And then finally, a lot of adjudications occur because an individual or an organization decides to protest some form of agency action. Now, a lot of times in the administrative adjudication realm, that agency action has to do with awarding a government contract or not, or providing some type of benefit or not. So if a veteran thinks that she's entitled to benefits, or a company thinks that it should have won a contract but didn't, they can protest the agency's decision via a formal adjudication. As I said a few slides back, the President and Congress can also impose procedural requirements on agencies for formal adjudications. And back in May, President Trump did just that via Executive Order 13924. That executive order's full title is Regulatory Relief to Support Economic Recovery, and it allows agencies to rescind, modify, waive, or otherwise provide exemptions to regulations that would hurt the national response to COVID-19 or hinder economic recovery from COVID-19. The EO also requires fairness in administrative adjudications, and it provides a list of steps that agencies must take to ensure fairness. So some of those steps are that adjudication officials should be separate and independent from enforcement officials, that agencies should bear the burden of proving a regulated party violated a law, including a regulation, that agencies must disclose favorable evidence to a regulated party, that rules of evidence in agency hearings must be public and clear, etc. Now, to be fair, most agencies were doing those things anyway, There's also an OMB memo that provides implementation guidance. And so I've got those posted in the classroom if you want to take a look at this executive order or the OMB memo. Because the formal adjudication process functions similarly to a court trial, adjudications tend to involve attorneys on both sides of the dispute. The process begins with notice to the regulated party. Before it can bring you into a hearing, you need to know that there's going to be a hearing. Next, the parties can engage in discovery, pre-hearing conferences, and settlement discussions. If settlement discussions fail, then the process moves on to an adversarial trial-type hearing where each party has the opportunity to present evidence, cross-examine opposing witnesses and evidence, make opening and closing statements, and so forth. After the hearing, the agency hearing officer must provide a written decision. That decision's got to be based on the hearing record. The agency hearing officer, normally an administrative law judge, we'll talk about that momentarily, they can only consider the information and evidence introduced during the adjudication process. That is very similar to a judicial opinion where the judge can only take into consideration issues raised during the trial process. And that does include, briefs to the court, pre-trial motions, etc. If a regulated party is unhappy with the agency's decision, it can appeal that decision. Sometimes it's got to go first to a board or commission within the agency, but ultimately it can get into the regular court system. So every part of the agency adjudication occurs in what we call an Article 1 tribunal. As a reminder, Article 1 of the Constitution sets up the legislative branch, Article 2 sets up the executive branch, and Article 3 sets up the judicial branch. Although agencies are in the executive branch, Article 2, we call them Article 1 tribunals because they are created by Congress. Now, Article 3 tribunals are what we would consider to be, quote, real courts. The kind that you're thinking about when you think about courts. These are constitutional courts. Full constitutional rights apply. Article 1 tribunals are not as powerful as Article 3 courts. That is because their power is limited to the quasi-judicial authority delegated to them by Congress. Now, there are a wide variety of Article 1 tribunals. Many agencies have their own adjudicative tribunal, agency hearing office, whatever they want to call it. In addition to the standard agency tribunals, Congress has also created things like the federal bankruptcy courts, the U.S. Court of Federal Claims, which hears government contracts disputes and other claims against the government, and the U.S. Court of Appeals for Veterans Claims. Now, these have court in their name, but they are not Article 3 courts. They are Article 1 tribunals created by Congress. Additionally, because Washington, D.C. is not a state, it doesn't have any Article 3 courts. So instead, Congress created the D.C. Superior Court and the D.C. Court of Appeals, which is different than the Court of Appeals for the D.C. Circuit. Unlike agency tribunals, these D.C. courts, the Superior Court and the D.C. Court of Appeals, they do handle the same matters that you would expect in a regular court of law. Now, in a regular Article 3 trial, civil or criminal, your case is heard by a judge, and you stick with the same judge, usually, from start to finish. There might be a federal magistrate in there, but traditionally you've got the same judge, especially once the trial actually starts. In agency adjudications, your case is heard by an administrative law judge, or ALJ, and you might have different ALJs for different steps in the process. So it's not unusual for one ALJ to preside over the hearing and then kick the case to a second ALJ to make the decision. There are around 2,000 ALJs employed by the 30-plus agencies in the federal government that handle administrative adjudications. So 2,000 ALJs as compared to about 870 Article 3 federal judges. Now, thanks to the Administrative Procedure Act, ALJs have the authority to do pretty much the same thing that a regular judge can do. They can administer oaths or affirmations, issue subpoenas, take depositions. They've got control of the hearing. They make decisions based on evidence presented at the hearing. They can hold settlement conferences, and eventually they make or recommend a decision at the end of the adjudication. Where ALJs really differ from Article 3 judges is independence. So independence is the hallmark of the judicial branch. That is why federal judges, so long as they are showing good behavior, serve for life. Independence is not the hallmark of the executive branch. And ALJs are executive branch officers. So because they're not in the judicial branch, ALJs are not entitled to the same protections as an Article 3 judge, including lifetime tenure. ALJs actually work for the agency that is a party to the adjudication. Now, of course, there is a greater chance for bias if you have to present your case against an agency to a person who works for that agency. And that's why Congress has provided ALJs with quasi-independence. So Congress provides for this quasi-independence in a few ways. First, ALJs are assigned to cases in rotation. So that keeps an agency from assigning a sympathetic ALJ to its case. When that happens in an Article 3 court, it's called judge shopping, and it is not supposed to happen. So you can complain about it. Second, ALJs can be removed only for good cause. So that shields an ALJ from agency retribution. If you're an ALJ and you rule against your agency, you can't be fired for doing so. Third, and along the same lines, ALJ salaries are set by the Civil Service Commission, not by the agency. So again, an agency can't punish an ALJ by docking salary or refusing to give a raise or taking any other type of retribution. Fourth, ALJs are selected from a list of qualified candidates, and they're selected by the Office of Personnel Management, OPM, not by the agencies that employ them. So this creates another buffer so that ALJs do not feel beholden to their agencies. Fair hearings require neutral ALJs. So again, you can't have an ALJ who is so beholden to their agency that they don't allow the other party to get a fair shake during the hearing. So to ensure neutrality, ALJs can't have any type of financial stake in the outcome of a case. They can't have a personal bias for or against one of the parties involved or the law or regulations, and they can't have prejudged the case. So typically, we rely on ALJs to recuse themselves if they've got any type of bias or if they think that they may have prejudged the case. And we also expect this from an Article 3 judge. The APA also separates the prosecutorial and adjudicatory functions to make sure that ALJs are independent. So you can't have an agency official investigate the case and have that same official also preside over the hearing or make a decision in that case. Also, as in Article 3 courts, ALJs cannot engage in what we call ex parte communications. So that is, ALJs can't speak privately with only one party. If an ALJ is going to communicate with a party, both parties have to be present. Not necessarily physically present. It can be a conference call, it can be an email, but really the ALJ just has to make sure that all of the parties are included in communications. So here are just some select agency tribunals. So this is just a list of some of these offices that hold hearings within agencies. It is nowhere near the complete list. Many agencies have some type of ability to hold a hearing. So I've got the symbols of the Social Security Administration's Office of Disability Adjudication and Review, or ODAR, the Veterans Affairs Board of Veterans Appeals, as well as the Civilian Board of Contract Appeals. These are all adjudicatory tribunals. You'll note that some agencies call their hearing office the Office of Administrative Law Judges. Others call it the Office of Hearings or the Office of Hearings and Appeals. It makes no difference. These are all agencies, tribunals that handle formal adjudications. The Social Security Administration has a particularly robust adjudicatory system, including ODAR, as well as a separate Office of Hearings and Appeals for non-disability related benefits. You can see that the Social Security Administration, it typically hands down many hundreds of thousands of decisions per year. We've got a drop-off to a mere 465,310 in up to Q3 of fiscal year 2020. That drop-off is a result of the pandemic. Now, regardless of which agency tribunal is hearing the case, all of these hearings begin with providing notice to the parties. All parties that are involved in the adjudication have to receive notice of the upcoming hearing. Additionally, interested parties are also entitled to notice. The APA requires that the parties to the case, as well as interested parties, be timely informed about the adjudication. The parties also have to know the legal authority under which the hearing will be held and the matters of fact and law at issue in the case. So notice is all about allowing the parties adequate time and adequate information so that they can prepare their cases. Notices fail if they are worded so vaguely or packed so full of legal or bureaucratic gobbledygook that a party cannot understand what the notice is telling them. Notices also fail if they are not issued far enough in advance. 30 calendar days is about the bare minimum notice that's acceptable. Notices will also fail if they do not specify the laws or the facts involved, because again, the purpose of a notice is to make sure that the parties can prepare their case. Now let's talk for a moment about interested parties, otherwise known as parties in interest. That's the official term. The APA does not define who counts as a party in interest, but clearly any party named in the adjudication is a party in interest. If the case is Social Security Administration versus Gartner, then I am an interested party, so is the Social Security Administration. People or organizations who are not named in the case can become interested parties by intervening in the adjudication. A lot of times, those interveners are competitor organizations who are going to possibly suffer economic injury based on the agency's forthcoming decision. If you think back to that case of General Motors versus FERC, it was about the pipeline. That's a situation where an economic competitor intervened in the case. General Motors was not originally involved. It was the pipeline company and FERC. But GM believed that it would be negatively impacted by FERC's decision regarding the pipeline company, and that belief was sufficient to allow GM to kind of force its way into the formal agency adjudication as an intervener. In addition to interveners, on that sort of corporate competitor side, anybody who's got standing to participate in a regular Article 3 trial is also an interested party at the agency adjudication. We will talk more about standing a bit later in the semester. The public itself can be an interested party. That usually happens through consumer advocacy groups or environmental groups. We will also talk about their ability to have standing a bit later this semester. Another set of interested parties are referred to as Ashbacker parties. That name comes from an Ashbacker case, which says that if a hearing is held to grant a license to one party, and granting that license would exclude all other parties from having that license or a similar license, then all parties that would be excluded are interested parties. Ashbacker situations are those in which the agency is playing a zero-sum game. One person wins and everyone else loses. Typically, we see this with radio stations and TV channels because there are a limited number of them. So if the government gives a certain station or a certain channel to one organization, no one else can have it. Interested parties, including those Ashbacker parties, they can be directly involved in the hearing. There are also non-parties who participate in the hearing, such as witnesses, unnamed members of class action suits, or organizations that file amicus briefs, aka friend of the court briefs, which happens a lot in Article 3 trials. It also happens in agency adjudications. After notice is given and the parties to the formal adjudication know what they're fighting about and why, the discovery process begins. Discovery is a pre-trial exchange of information. It is designed to make the hearing fair and efficient. Basically, the hearing should run smoothly. And discovery is there to ensure, to the extent possible, that there are no surprises that interfere with that hearing running smoothly. So surprises during trials, they make for great television, but in reality, all they do is mess up the hearing and possibly require that the parties start from scratch. So it is in everyone's best interest to avoid these gotcha moments during hearings. Discovery allows the parties to gather information, including information from non-parties. Discovery also works to support pre-trial settlements. Hearings, like full court trials, can be very expensive, both in terms of time and money. So the APA supports settlements, and ALJs tend to push the parties towards a settlement. And a lot of times that actually works in favor of the non-governmental party, because the government has a lot more money than its opponent, and it can withstand a much lengthier process because it doesn't have to pay for outside counsel. So as an example, I've been working on a matter for over a year, and we had to obtain outside counsel for it. And in the DC area, law firms charge anywhere from $550 to $1,800 per hour. So having an attorney for a single day can be very expensive for a regulated party. Now, there are rules that govern the discovery process, but they don't come from the APA because that doesn't really mention discovery, and they don't come from the Constitution because the Constitution does not mention agencies. Instead, a lot of agencies have created their own rules about the discovery process, and they've got to abide by those rules. Additionally, some of the federal rules of civil procedure and federal rules of evidence apply to agency adjudications. And those rules allow the parties to request anything that is reasonably calculated to lead to the discovery of admissible evidence. If a discovery request is unreasonably burdensome, the party is not required to respond to it, although you should not respond to it through your ALJ rather than just ignoring a discovery request. So for example, if the IRS were to suddenly ask you for 40 years worth of receipts, that would be considered far too burdensome because nobody keeps 40 years worth of receipts, and also you only have to keep your tax records for 7 years. If the EPA were to demand the production of all documents related to the adjudication within 7 days, that's unreasonably burdensome, both because of the quick turnaround time and also because that's kind of a vague request. You might have to engage in discovery to figure out which documents are actually related to the adjudication. The discovery process, it also does not reach privileged information. Privileged information cannot be used at the hearing unless the person who holds the privilege allows it. There are several standard forms of discovery. In a deposition, the party or a witness must answer oral questions under oath. So you're actually either there in person or you're doing some type of telephonic or video deposition. The party ordering the deposition has to give notice to the other party and also to all of the witnesses. And all parties to the adjudication must be able to question the person being deposed. Interrogatories, they're similar to a deposition, except they're all written questions. They're not oral questions and responses. The person answering the interrogatory is still under oath, but there's no chance for cross-examination. Interrogatories are generally the first form of discovery that you would want to use because the answers help inform whether you want to have depositions or ask for the production of certain documents. So speaking of that, A request for the production of documents requires the other party or a witness to produce those specified documents. The party making the request should be very careful to be specific when asking an adverse party to produce documents, because if you're not careful, the other party is going to bury you in documents and you're going to have to waste time and resources trying to find the specific information that you're looking for. Requests for admissions, they are another popular form of discovery. They're basically just written statements to which the other party has to say, yes, that's true, or no, that's false. Then there are subpoenas, which are orders to produce documents or testimony. Subpoenas are agency orders or court orders that require a person to testify or produce specified documents. You could see here is the GSA's Office of Inspector General issuing a subpoena for specific documents. Subpoenas are crucial to an agency's ability to enforce compliance with laws and regulations. If an individual or an organization refuses to provide required information, an agency can issue a subpoena to compel production. So that is, they can force the organization to provide that information. Now, agencies do not have inherent authority to issue subpoenas. Congress has to grant that authority to them. Additionally, administrative subpoenas, like we discussed last week, they are subject to the Fourth Amendment. They're subject to relaxed Fourth Amendment requirements, but they are still subject to the Fourth Amendment. So an agency must be acting reasonably in issuing a subpoena, even though probable cause is not required. Agencies also lack the power to punish individuals or organizations who ignore the agency subpoena. That doesn't mean that you'll get in trouble. It just means that agencies are going to go to the courts to seek an order to enforce their subpoenas. Before you get to the hearing, there are a variety of pre-hearing conferences. There can be just one or there can be many. These are authorized by the Administrative Procedure Act, and they're used to settle certain issues or simplify issues. Pre-hearing conferences are also a source of discovery because you get a chance to speak with the opposing party and you can collaboratively identify sets of issues, agree on certain sets of facts or certain interpretations of the law. You can review evidence already collected, and you can review the opposing party's witness list. Now, like I said, there can be multiple pre-trial or pre-adjudication hearings. It's not necessarily a one-time event. And the more complex a case, the more likely it is to have multiple pre-hearing conferences. So for instance, alleged violations of environmental laws, where there's a lot of scientific and technical information, there are going to be multiple pre-hearing conferences to try to get through that. Parties can also use pre-hearing conferences to engage in settlement discussions. The APA does require agencies to at least consider settlement offers. In addition to reaching a decision through an informal settlement talk or through a full adjudication, there are some other methods of settlement that fall under the term alternative dispute resolution, or ADR. And that usually refers to mediation, arbitration, or binding arbitration. Mediation is more relaxed and informal. Arbitration is more like an agency hearing, except that you're in front of a neutral arbitrator. Binding arbitration is like an agency hearing, but you cannot appeal the decision into the court system. Personally, as an attorney, I am not a fan of any type of binding arbitration under any circumstances because it really closes the doors to the courthouse to you. The hearing itself in a formal adjudication is a full-on trial-type hearing like you would see in a regular Article III court. That formal process is required if the statute uses the magic words on the record after opportunity for a hearing. There are other times when you might get a full trial-type hearing, even if the statute doesn't contain the magic words. So unlike rulemaking, where agencies will never engage in formal rulemaking unless the statute requires it, agencies will engage in formal adjudications even when not required by statute. And that could be because the agency has its own rules that require a full trial type hearing, or the due process might require it. So if it's unfair for a party to be denied a full trial type hearing, then the agency's got to provide it per the due process clauses, regardless of statutory language. Formal agency adjudication hearings, these are very similar to civil trials, and the overall process is very similar to what you would see on Law and Order or any other TV show about lawyers that makes at least a passing nod to realism. So the hearing includes opening and closing statements, the presentation of evidence, examining and cross-examining witnesses, and objecting to evidence that you don't think should be introduced. In an Article III court trial, the federal rules of evidence prohibit the introduction of untrustworthy evidence, irrelevant evidence, or unduly prejudicial evidence. But agencies don't have to follow the federal rules of evidence for the most part, and instead, they can listen to or review any oral or written evidence subject to a handful of rules that do prohibit irrelevant or excessively repetitive evidence. One of the historic differences between agency adjudications and Article III court trials is that hearsay is permitted in agency adjudications, but not in court trials. We hear the word hearsay quite a bit, but a lot of people don't actually know what it is. And the definition of hearsay is an out-of-court statement made by someone who is not a party or a witness that is used in court to prove the matter asserted. So let's say you call Joe as a witness, and Joe testifies that Bill told him that Nancy was in town. The ALJ can use this statement as evidence that Nancy was in town, even though Joe did not see Nancy, and Bill, who did see Nancy, is not being called as a witness. In a regular Article III court, Joe's statement that Nancy was in town, that Bill told him Nancy was in town, that would not be admissible as evidence that Nancy was actually in town. The party that wants to prove that Nancy was in town would have to call Bill as a witness because he's the one with first-hand knowledge. What Joe says, because he does not have first-hand knowledge, would be excluded as hearsay. Now, the relatively new executive order on regulatory reform and agency fairness that we saw a few slides back, along with the implementing memo from OMB, those do impose more limits on the use of hearsay in agency adjudications. So it might be on its way out. We'll just kind of have to wait and see. Now, agencies do have to exclude certain types of evidence. They've got to exclude irrelevant evidence, immaterial evidence, or evidence that is repetitive. And that's just because there are only so many times that you need to hear the same information stated in different ways. Burdens of proof are also applicable to both agency adjudications and regular Article III court trials. The burden of proof simply means the obligation of a party to prove its case. And that breaks down into two distinct parts. There is the burden of production and the burden of persuasion. So the burden of production is the party that has that is the party that has to produce the evidence that supports its take on the issue that it is raising. The burden of persuasion is which party has to convince the ALJ that they are correct. Usually the same party has both burdens. If you think about a criminal trial, the prosecution has to produce enough evidence to prove its case, and it also has to convince the judge or jury that that evidence all adds up and supports the fact that the defendant is guilty. Similar type of thing in agency adjudications. It is worth noting that Social Security claims are one of the main exceptions to this rule, that the burden of proof, that both parts of the burden of proof are on the same party. For Social Security claims, the person who is claiming the benefits has the burden of production. They've got to show, for instance, that they are disabled, but they do not have to persuade the ALJ that they deserve the benefits. It is the agency that has to satisfy the burden of persuasion and prove that even though the person is disabled, they are not entitled to benefits. So while that is an outlier, because the Social Security Administration hears so many claims per year, it is an important factor. There are also standards of proof. They relate to the burden of proof. Basically, the question is, how much do you have to do to meet your burden? What is good enough to win the case? In a criminal trial, the prosecutor's got to prove their case beyond a reasonable doubt. There has to be overwhelming evidence that leaves no real room for doubt in the mind of the judge or jury that the defendant is guilty. In Article III courts during civil trials, the burden is a preponderance of the evidence. That means that it is more likely than not that a plaintiff has proved her case. That can be as little as 51% to 49%. That is still a preponderance of the evidence. In administrative adjudications where there are civil liberties threatened, like for instance, if you're a prisoner and now you're going to get locked up in a supermax prison rather than a regular prison, or be put in solitary confinement rather than in general population, or if you're in a deportation hearing and you risk being deported, then the agency has to show clear and convincing evidence. That is a standard where it's more than 51%, but it is less than the overwhelming beyond a reasonable doubt standard. Congress can specify the standard of proof that an agency has to meet, but it's going to be one of those three standards: preponderance of the evidence, clear and convincing, or beyond a reasonable doubt. And in agency adjudications, it's more than likely going to be the preponderance of the evidence. After the hearing, there is a decision, obviously very important in both agency adjudications and Article III court trials. Unlike in an Article III court, the APA gives the parties the right to submit their own proposed decisions. These are usually called proposed findings of fact and conclusions of law. Before the ALJ issues a decision, he or she can hear from both parties on how they think the decision should shake out. In an agency adjudication, the decision is only final if the agency head presides over the hearing or issues the decision, and that is very rare. So the vast majority of agency adjudications end with initial or recommended decisions. You can see here on the screen, I've got one from the Consumer Financial Protection Bureau. It is a recommended decision. So the ALJ can issue an initial decision that becomes final if the losing party does not appeal, or the ALJ can issue a recommended decision which has to be certified and transmitted to the head of the agency before it can become final. Most of the time, ALJs issue initial decisions. Those can be appealed, often first to a board or a commission within the agency, and then to a regular Article III court. ALJs cannot issue final decisions because they are not agency heads. But like I said, their initial decisions do eventually become final if they're not appealed. For findings in formal adjudications, the APA does require some specifics. The decision has to be part of the record, so that's because the court has to be able to review both the record and the decision. The APA requires that ALJs provide a written statement of findings of facts and conclusions of law with a reason for those findings and conclusions. It's very similar to the court's rationale in its court decision. This provides accountability because the decision is committed to writing. It improves the ALJ's decision-making process because it requires the ALJ to engage in a reasoned analysis. Written decisions also educate the public. They can be read just like court opinions. And they can provide precedent in that individuals or organizations can use past decisions to make an educated guess on how the ALJ is going to rule in the current case. They also, like I said, having them in writing, it provides for meaningful judicial review because it's part of the written record. So ALJs find facts, they reach a conclusion, they render a decision, and then they have to explain that decision in writing. Now, parties generally have the right to counsel at administrative adjudications. Counsel is often an attorney, but it doesn't always have to be. Some agencies permit non-attorneys to represent the parties. Each party's got to pay its own attorney's fees. Like I said, those can get very expensive. The APA does allow a regulated party to petition the government for a reimbursement of those fees. So theoretically, this protects small businesses from overzealous agencies because the agency is going to have to pay out if it loses. However, that reimbursement is usually limited to about $125 an hour for attorneys, so it's pretty doubtful that that would make much of a dent in a party's attorney fees. Witnesses are also entitled to fees under the APA. Regular witnesses get a whopping $40 a day to attend. They also get travel, lodging, and meal costs reimbursed up to the GSA's per diem cap on reimbursement. Expert witnesses, they get paid a whole lot more money by the regulated party, but the regulated party can seek reimbursement for those expert witnesses if it prevails at the hearing. Let's take a look at a specific FCC adjudication. That is the Federal Communications Commission. So long ago and far away, specifically on February 1st, 2004 in Houston, Texas, the Super Bowl halftime show kicked off one of the lengthiest and most memorable examples of an agency adjudication. So that Super Bowl was aired on CBS, which was owned by Viacom, and during the halftime show, Justin Timberlake ripped off a part of Janet Jackson's outfit, and her nipple was visible to the worldwide audience for 9/16 of a second. That created quite a stir. Members of both houses of Congress expressed outrage about the indecency of this wardrobe malfunction. Then FCC Commissioner Michael Powell called it a new low in broadcast. And all sorts of conservative groups urged their members to call the FCC and complain because there are federal laws and regulations that prohibit the broadcast of indecent material. So pursuant to its statutory and regulatory authority, the FCC engaged in an informal adjudication, and then it levied a $550,000 fine on CBS. And at the time, that was the largest fine ever levied against a broadcast network. The halftime show also caused the FCC to modify its regulations to include a prohibition on fleeting indecency, as well as the already existing prohibition on fleeting expletives. So CBS paid the fine so that it could challenge the FCC's action, which it did in November 2004. So then that proceeded to a formal adjudication. There was a hearing, and the FCC affirmed the fine in March of 2006. Now, by that time, the majority of respondents in various national polls, including one by Time magazine, said that the FCC had overreacted to the wardrobe malfunction. In July of 2008, the Third Circuit Court of Appeals, in a 208-page opinion, voided the FCC fine on the grounds that the enforcement action was a significant deviation from prior practice and that the FCC had not announced that as a clear policy change. The Third Circuit also held that the FCC was attempting to sanction CBS retroactively after it added this fleeting indecency regulation. So in other words, the regulated parties were not aware of their new compliance obligation and should not be fined for violating it. The FCC then appealed from the Third Circuit ruling. Appealed to the Supreme Court, which in May 2009 vacated the Third Circuit ruling and sent the case back to the Third Circuit to decide again, this time in light of a recent Supreme Court decision that said broadcasters could be held responsible for unscripted, vulgar words and fleeting expletives. So the Third Circuit took the case again. And over 2 years later, in November 2011, the Third Circuit again ruled in favor of CBS. It found that the Super Bowl halftime show broadcast was legal under the FCC's regulations at the time, and it was unfair of the FCC to change its policy and enforce that change retroactively. In June of 2012, this is 8.5 years after that wardrobe malfunction seen around the world, the Supreme Court declined to hear the FCC's second appeal from the Third Circuit. And about a decade after the incident, former FCC Commissioner Michael Powell, he admitted that that controversy over the wardrobe malfunction at the Super Bowl halftime show was completely overblown. He even said, his own outraged reaction was kind of ridiculous. So there you have it, one of the longest agency adjudications that stretched into court trials in recent memory, all because of a wardrobe issue that lasted only 9/16 of a second. So that is just barely over half a second. So the Super Bowl halftime show back in 2004 generated a huge number of complaints to the FCC. But interestingly, or at least interestingly if you are an NFL football fan, there are quite a few NFL-related complaints filed with the FCC every year. Between 2012 and 2015, the FCC received 150 complaints related to NFL games. Most of those complaints were about the Washington football team's name, which is a racial slur, or the fact that it's super obvious that you could see players and coaches swearing on the sidelines. There were a couple of complaints against Tom Brady, for instance, who dropped the F-bomb many times, and it was recorded and very clear to the audience. What I found unusual was that not included in any of those complaints was a complaint against NBC for its Sunday Night Football coverage of a Patriots-Ravens game in September of 2012. That was the season of the replacement refs. They were universally regarded as quite terrible. So after a bunch of blown calls, the fans at M&T Bank Stadium in Baltimore, they just finally lost it when there was a dubious contact penalty call that negated a Baltimore interception, and then an unsportsmanlike conduct call against Ravens coach John Harbaugh. And so the stadium erupted into a very loud, very lengthy, perfectly in unison chant of bullshit. I mean, you can look at the video, I've got it posted in the classroom. It is a loud chant. And while it wasn't surprising that an NFL, group of NFL fans at a stadium might use a naughty word, what was striking was that NBC aired that repeated bullshit chant for over a minute without bothering to obscure the sound. In fact, it was so loud and went on for so long that Sunday Night Football announcer Al Michaels said it was the loudest manure chant he had ever heard. Now, strangely, no one filed a complaint about this, not even the Parents Television Council, which can always be counted on to file complaints with the FCC. The day after the game, the FCC said that it was looking into it, but then quickly decided not to bother, telling TMZ Sports that it did not impose penalties for obscenities inadvertently heard over the air. Now, given the fact that the FCC has a regulation that it can impose penalties for fleeting expletives, it's very odd to me that they didn't even really look into the fact that this incredibly loud bullshit chant aired on a network during prime time, although it was probably later in the game, so a bit later on the East Coast. Now, my assumption personally is that everyone, including the FCC and the Parents Television Council, agreed that the replacement refs were so horrible that the chant was an appropriate display of First Amendment rights. But that is just my personal opinion. Okay, well, that is it. There is nothing due this week. However, if you haven't posted many news items, please start. You got to post 5 of them by the end of week 15. Only 1 per week counts for credit. But otherwise, nothing is due this week. I hope that you guys have a wonderful week. I might see you on the discussion boards, and if not, I'll see you next week.